Sri G. Ram Gopal Garu. He is the current 5th Additional District Session Judge, Tirupati. So I would like to invite Sir to give a brief introduction on his inputs on Evidence Act. Sir, please, sir.
Thank you. Good afternoon to all. Why you are so nervous? Because since morning you have been attending classes. Is it so? Have been attending classes since morning? It's okay. I used to say law is a ocean. Its boundaries are, its horizons are ever widening and depth is unfathomable. No one can claim that he is a master in law. I don't know how long have been practicing as advocates and when you have passed law exams. Anybody practicing an advocate? No. You are now just completed law degree. Pursuing law, simultaneously you are also preparing for examination of junior civil judges. It's okay, good. At the outset, I congratulate all the participants who are present here as well as students who are hearing online classes. You see, I would like to share certain aspects in Evidence Act. I tell you both Telugu and English. Wherever required, I switch over to Telugu, and otherwise I will speak to you in English. You know, hitherto Evidence Act 1872, now this is the said Evidence Act is totally repealed and new act came into force with effect from 1/7/2023, which is named as Bharatiya Sashi Adhinayam 2023. So this act would apply to the cases coming up from 1/7/2023 and prior cases which have been pending in the courts. We have to follow the Evidence Act of 1872. There are only small amendments in the present Sashi Adhinayam. Most of the provisions which were there in the Evidence Act 1872 have been incorporated in the Sashi Adhinayam 2023. So Evidence Act is concerned. There are no major changes, but some few changes are there. You can go through those provisions and understand. Now, I don't want to tell each and every provision of you, which is practically not possible in the today's class itself, within 45 minutes, 1 hour class. Therefore, I wanted to say certain aspects covering Evidence Act. Forget about the present Sashi Adhinayam and also the previous Evidence Act 1872. I am not going to deal provision to provision, either the present act or the repealed act. But I tell you the points involved, major points involved in the said evidence in the Sashi Adhinayam or Evidence Act. So both both acts, these points are very similar. See, there are two types of laws: substantive laws, procedural laws. Substantive laws deal with rights, liabilities, duties, etc., etc. Procedural laws deal with the procedure to be adopted to ascertain or to how to find out the rights and liable duties which we follow in substantive law. So Evidence Act is concerned, it is a procedure law mostly. So it is Evidence Act is also called as adjective law. Evidence Act is also called as adjective law. There are the entire Evidence Act deals with two aspects. One is quid pro bono and second one is modus probandi. The entire Evidence Act mostly deal with two aspects. Quid pro bono, which means thing to be proved. Second one is modus probandi, the mode of proving. So the entire Evidence Act deal with these two aspects. So how evidence is to be proved and what to be proved. These two aspects are dealt with in the Evidence Act. So normally, what is meant by evidence? What is meant by evidence? Anybody can tell? That's a statement of what is evidence is defined. What is evidence is defined under the Evidence Act. Now, in the Sashya Adhinayam, electronic evidence is also included. Hitherto, electronic evidence is not specifically covered, but in view of new Act of Evidence Act, electronic evidence also included. So there are certain provisions under definition category. So one has to understand those definition clauses invariably. What is relevancy, admissibility, proof, probative value, presumptions. Say what is meant by fact. Say unless and until you understand these preliminary aspects, you can't understand the Evidence Act also. So you must understand what is meant by fact, what is meant by relevancy, presumptions, proof, evidence. These are the small things which you need to understand. Now I am going to deal you mainly 4 or 5 aspects Evidence Act is concerned. One is relevancy, admissibility, proof, probative value of proof. These 4 aspects now I would like to tell you in brief. So to understand what is relevance, so we have to go through the provisions of Indian Evidence Act as well as Sashya Adhinayam 2023, because there are similar provisions. So always court wanted truth. See, there are two parties, both parties come to the court to say I have a right and another party he has right. For example, in civil cases, Ramaya, you called it one Ramaya, comes to the court and say that B. Subbaya borrowed 1 lakh from me by executing a promissory note, and he is now not paying in spite of my demands and requests. Therefore, you decree, court is requesting the court to decree the suit and get it recover the amount by court of law. Then what court will register the case, issue summons to the opposite party, and he will come to the court. He says that he never borrowed any amount. This promissory note is a forged or fabricated document. Therefore, I need not pay any amount to the Ramaya. Subbaya says like this. Then the court will see what are the aspects before the court. Really, the Subbaya borrowed 1 lakh from the Ramaya or not, whether the suit promissory note is true or not, court has to decide by framing certain issues. So where court required truth, So courts are meant for to render justice to the parties. So what is truth? Court has to ascertain whether really this A. Ramaya lent the amount to the Subbaya, and Subbaya executed a promise note in favor of Ramaya X. Then the evidence let in by both parties, and cross examination will taken place, and ultimately arguments will be submitted. Ultimate judge has to give finding whether really Ramaya borrowed or not, where court see what is truth, whether this man is telling truth or that man is telling truth. So that is a matter of appreciation of evidence that is covered under Evidence Act. See, normally out of experience of a judge, there are no rules and canons how to appreciate evidence. So normally by experience of a judge and following the precedents of high courts, honorable high courts and Supreme Court, and also the provisions of Indian Evidence Act, we judges will give judgments giving this is a fact. So if court believes that the A. Ramaya lent the amount and promissory note is true, then we will decree following other parameters, whether suit is filed within the limitation, whether the court has jurisdiction or not. Other aspect will be also seen, and ultimately will give a decree in favor of Ramaya. Court doesn't believe the version of A, then what court will do? Will dismiss the suit. You have never borrowed, that you have never lent the amount to the Subbaya. So you filed a suit with a fabricated and forged promissory note. Therefore, you are not entitled decree. Therefore, ultimately suit will be dismissed. So what I want to say, when this is one example in a civil case. Likewise, so many examples we can give regarding properties. One man says, I am the owner of this property. Another man says that he is the owner of the property. When both parties claiming the property and come to court that no, you give the decree in my favor, and the other man, so no, dismiss the suit, though he is not the owner, I am the owner. Where also court has to decide who is the owner. The element required is what is truth. See, in a criminal case, another example, in a criminal case, A murdered B. A was prosecuted in a court of law. Police registered the FIR, investigate the case, filed final report. Normally we called it a charge sheet. Then evidence comes, and the point before is whether A committed a murder. A committed the murder of B or not. So then the burden of proof lies on the prosecution. In a criminal case, burden of proof always lies on the prosecution. So prosecution has to prove that A murdered the B. Then we can award sentence, where also whether really A committed murder or not. So many facts, so many aspects to be dealt. So now that's the reason why we must understand what is relevancy, what is fact. Truth is not defined in Evidence Act or Sashya Adhinayam, but fact is defined. What is fact? What is the definition of fact defined under that Evidence Act? It is not a exhaustive definition. It is inclusive definition. Fact means anything, state of things, relation of things capable of being perceived by senses. This is the first part of the definition of the fact. Second part of the definition is any mental condition of a person which is conscious is also fact. So there are two aspects involved in the definition of the fact. One is physical facts. Second definition, psychological, mental facts. Psychological facts are mental facts. So physical facts, normally, suppose I am addressing you, book is on the table. So whatever we observe with senses, what are the senses? How many senses are there to human body? Human. There are 5 senses. What are they? Eyes, nose, ears, tongue, skin. There are 5 senses. Whatever we observe from these 5 senses directly, and we give evidence what we have seen, what we have heard, what we have observed with other senses would become evidence. This is called physical evidence. The second one is mental status or psychological facts. Normally, psychological facts cannot be directly be seen or heard or pursued. Then how it would be? So the psychological facts can be inferred from the existing facts. You see, I don't know, you are listening. You are all sitting in the classroom as students, and I am teaching to you. This is a physical fact because you are all observing me and I am observing you. This everything is physically is witnessing one by one. Is it not? But I don't know what is your understanding about me, how you are thinking about me, and how I am thinking about you. It only I have to guess and draw certain inferences from seeing your faces. See, supposing one person is not at all concentrating on my speech, on my lesson, and some student is actively participating and is understanding class, I can observe from reading your faces. And you also can think something about me, whether this officer, the judge is telling the lesson correctly or not. You can imagine this class is not good, or and is not telling the evidence act properly. Like that you can see something. So that can also I can draw certain inferences from you. Thus this part tells about undedi. So inferences and also presumptions. Presumptions are dealt, inferences and presumption dealt under the evidence act. See, now we have to keep in mind the facts are categorized into 2: physical facts, psychological facts or mental facts. Physical facts can be directly tapped by 5 senses, but psychological facts we have to draw certain assumptions, presumptions, inferences from the existing facts. These are all included in the evidence. Now, have you followed? See, then second aspect is what is relevancy. So relevancy, we may say so many things about the relevancy, but we can't say as per my wish and fans, or every individual cannot say this is relevant and this is not relevant. There we are governed by the Evidence Act. Therefore, under Evidence Act, clearly stated what are the relevant facts. So relevant facts are only permissible in a case or a list before a judge to decide any case. the facts which are not relevant cannot be permitted either to come on record as evidence or even in the pleadings of the parties. Therefore, what are the relevant facts? One has to read the provisions of Evidence Act, Old Evidence Act and present Sashi Adhinayam. Okay. See, one fact is not relevant to another when they are not connected with each other. See, there are so many things because in under Old Act there are certain provisions undedi. If I want to tell in detail, it takes time. I will tell a few provisions under the relevancy aspects. See, facts otherwise relevant are relevant. Facts otherwise relevant, otherwise not relevant are relevant. Where it is dealt under Old Evidence Act 1872, Section 11 of Evidence Act deals with facts not otherwise not relevant or relevant. See, what is your understanding about that? Have you gone through that provision in your classes? No. Facts otherwise, one way is saying those facts are not relevant. What I said earlier, so the relevant facts are only admissible and only the courts will permit the parties to adduce relevant facts to the case. Facts which are not relevant cannot be permitted to come on evidence. Again the provision says facts otherwise not relevant are relevant. Say that is dealt under Section 11. There is a relevant provision under this old act, the present act also. You see, in a legal parlance, it is called as plea of alibi. Have you heard the word alibi? Are you not dealt with Evidence Act in your classes? No, plea of alibi. For example, there is an allegation, there is a case against X that X committed murder of B Ramaya Subbaya. He says he came to the court that I have never committed murder of X. Even there is no possibility to commit murder. I was elsewhere, though I was in America or somewhere which is not possible to commit murder at the particular point of time. You see, today murder taken place in Tirupati at 10 o'clock. So at 10 o'clock he is able to prove that he is in the USA. So that fact is relevant. Facts otherwise not relevant but relevant. The statute provides, Old Evidence Act says that is relevant. If the accused in a criminal case is able to establish by way of preponderance of probabilities that as on the date of committing crime or at the particular point of time he was elsewhere and practically it is not possible to present at the scene and commit murder of X. See, normally in criminal cases, any fact is to be proved by way of proof beyond reasonable doubt. In criminal cases, any fact is to be proved beyond reasonable doubt. What is meant by reasonable doubt? So, అంటే ఎటువంటి సందేహాలకు తావు లేకుండా ఆయన మర్డర్ చేసినట్టుగా వాళ్ళు ప్రూవ్ చేయాలి ప్రాసిక్యూషన్ పార్టీ. సివిల్ కేస్, ఇన్ కేస్ ఆఫ్ సివిల్ ది ప్రూవ్ బియాండ్ రీజనబుల్ డౌట్ ఈజ్ నాట్ ది హాల్ మార్క్. ప్రూవ్ బై వే ఆఫ్ ప్రొపాండరెన్స్ ఆఫ్ ప్రాబబిలిటీస్ ఈజ్ సఫిషియంట్. దిస్ ఈజ్ a general rule. As a student of law, as a lawyer, or even if you become a judge, you have to keep in mind this principle. In all criminal cases, normally the prosecution has to prove its case beyond all reasonable doubt. Any criminal case. There are certain exemptions where a plea of alibi is taken, that the accused has to establish that he was elsewhere, and that proof is not required by a proof beyond reasonable doubt, but it is sufficient, is able to establish by way of preponderance of probabilities. In a civil case, proof beyond reasonable doubt is not necessary. Proof by way of preponderance of probability is sufficient. That is, you have to keep in mind always. Now, this relevant aspect is concerned, though that aspect is not directly relevant because the accused is alleging he has not committed murder and he was somewhere at the particular point of time. Practically, it is not possible for him to be present at scene and commit murder. Therefore, request the court to acquit him. Suppose if he is able to prove by a preponderance of probabilities that he was in somewhere, not at the scene at the time, particular point of time, court can give benefit of doubt and acquit him. So, this is one aspect of relevancy. Though I will tell another one and switch over to another aspect. See, identification is concerned. Sometimes in a midnight, certain robbery is taken place, dacoity is committed, and the assailants, after committing robbery or dacoity, left the place. Otherwise, murder is taken place in a dark time. Assailants are not so recognized people. Immediately after the incident or the offense, they left the scene. The eyewitnesses who have seen that accused or assailants, they can identify their faces, etc., etc. So then it is for the investigating officer to conduct prior test identification parade. So that is relevant aspect covered under section 9 of Indian Evidence Act. So that evidence, see, the eyewitnesses identified the accused involved in any crime, and the concerned magistrates will conduct test identification parades in the jails, calling the witnesses and accused who are inside the jail, and he will conduct some parade whether he is identified or not. Will get the record, will prepare the proceedings and file in the court or hand out to the police. That evidence also is relevant, but it is not a substantive evidence. That can evidence, that identification evidence can be considered as a corroborative evidence to the evidence already on record with respect of identification of accused. So here the substantive evidence, what is meant by substantive evidence, what is meant by corroborative evidence also need to be seen. So relevancy is concerned. So even prior identification, conducting prior identification proceedings under section 9 of World Evidence Act is relevant. This new act is also dealt with the subject. So likewise, if you go through section, old provisions of section 5 of 55 of Evidence Act, for everything, motive, preparation, say, photography, everything, the admissions, confessions, these are all relevant. Now, relevancy aspect is concerned, I will tell a major portion. Admissions are also relevant. Admissions made by a party either in the pleading or in the evidence are relevant. Admission made by the witnesses of a parties are also relevant. Admissions are two types. Admissions by way of pleadings. Pleading means plaint and written statement in the civil cases. are admitted by a party in any document. See, admissions in evidence. For example, in a Highcourt earlier example, A says that B borrowed 1 lakh and executed a promissory note. He filed a suit, and B comes to the court saying that I borrowed amount. He is admitting debt, but took a defense that he repaid or discharged the debt. So what is the admission there? He is admitting the debt is admission. He filed return statement stating that I borrowed the debt, but I have discharged the debt. So this plaintiff again need not prove the debt. The plaintiff need not prove the debt. Why? The defendant is admitting the debt. Admitting the debt by of return statement. His own pleading is admitting. Therefore, no necessity to produce any evidence by the plaintiff A to prove the debt given under a promissory note, because the defendant himself is admitting debt. The fact or point or issue to be decided in the such case, what is whether he discharged or not. Once discharged, you can't decree the suit. So then the burden lies on the defendant. The court will see only in that aspect. Plaintiff alleging that B borrowed debt under a promissory note, B admitting the debt, took a plea of discharge. Therefore, once debt is admitted by the defendant B, plaintiff need not prove. It is for the defendant to prove that he had discharged the debt. Therefore, he has to prove that he discharged the debt. If he fails to prove discharge debt, then suit will be decreed. You see, so admissions by of return statement are a plaint. Party cannot come and say no, I will not. So he admitted in the return statement. You see, then again now saying that I have not borrowed by coming into the witness box, so court will not permit. So in a civil cases, the cardinal principle, age-old principle is that, or otherwise it can be said is elementary in civil law, that one must plead and prove his case. He must present a plaint setting out his case, and defendants also must set up his case, then let in evidence. So a party cannot be permitted to travel beyond pleadings. He must put a basis, then adduce evidence. See, once admitted, he cannot go back. So having admitted either debt or any fact in issue, so again he cannot go back against his pleadings. So admissions given in the pleadings are relevant. Admissions given in the evidence are relevant. Okay?